Welcome. Today's webinar is Avoiding Costly Legal Pitfalls in Wound Care. I'm Deborah Kurtz and I'm your moderator today. For those of you who are just joining us, our participants just took a quick poll and shared with us their background. And in case you didn't see the results, we have 82% from nursing or nursing management and 10% are long-term care administrators, with various other folks representing the rest. Wanted to go over what we'll be accomplishing today. First, I'd like to introduce to you the speakers. Our first speaker will be Scheurich, who's an RN and a CWOCN. She's also the Director of Clinical Services for WoundRounds, who is one of our sponsors today. Anne will be speaking to us in the first part of our webinar about avoidable versus unavoidable pressure ulcers, as this clinical differentiation is an important driver for the legal questions that we'll be covering later in the presentation. Our second speaker today is Tim McVey, and Tim is an attorney with the law firm of McVey and Parsky. McVey and Parsky are also one of our sponsors today in this webinar, and Tim comes to us with a distinguished background in representing long-term care facilities in battles that often surround themselves around wound care. And as you can see, Tim has handled many such cases in his distinguished career, so we will be interested in hearing his comments later in the webinar about legal pitfalls. Myself, my name is Deborah Kurtz. I'm an expert in the industry of both healthcare and wound care, and I'm acting as your moderator today. So I'd like to briefly cover what we'll be discussing today in our webinar, Avoiding Costly Legal Pitfalls in Wound Care. Our first step, we'll be hearing from Scheurich from the clinical side of avoidable versus unavoidable pressure ulcers, because obviously if we can prevent wounds, there's less grounds for us to get into legal problems later. Anne will be covering for us 8 critical steps that are involved in documenting wound care, and she'll be covering documentation standards. Then we'll be turning the webinar over to Tim McVey, who is an attorney, who will be giving us a legal perspective, will be helping us understand and bring to light the legal viewpoints behind documentation. He'll show us case studies, and he'll also go into a detailed portion of documentation known as wound photography. So at this time, I'd like to turn the webinar over to Scheurich, who is with WoundRounds as Director of Clinical Services. Anne, welcome to the webinar today.
Thank you, Deb, and thanks for joining us today. We're going to talk about the avoidable pressure ulcer and how to document against it to start off our day. As we know, avoidable pressure ulcers introduce a risk for an organization, and when a pressure ulcer occurs, litigation can be involved. Then the burden shifts to the defense team to prove that the pressure ulcer was unavoidable. Litigating these cases can run into 7-figure expenses, and nobody wants to go down that road. The key is to adopt best practices and to minimize occurrence of pressure ulcers in your facility. The National Pressure Ulcer Advisory Panel, or the NPUAP, is recognized as a source of information on best practices. And as you can see on your slide, they define very clearly an unavoidable pressure ulcer can develop when the provider did not do one or more of the following. We need to evaluate an individual's risk. We need to define and implement standards. And we need to set individual goals. So let's look at those steps individually. With regard to avoidable versus unavoidable, there are essentially 8 steps to remember when documenting, and they're listed on the slide. When we evaluate the individual's clinical condition and pressure ulcer risk factors, it's important to use a standardized tool. It's recommended by the NPUAP as well as the WOCN. A standardized tool supports best practices. The 2 most common standardized tools for risk evaluation are the Braden scale and the Norton scale. Both of these scales are clinically validated and support best practice documentation. Standards of practice dictate assessment be done on admission to a facility and with any change in condition, and more specifically in long-term care, upon admission, weekly for a month, and then monthly is the recommended standard. Following standards closely keeps you in compliance and allows you to respond to changes in a more timely manner. Define and implement interventions consistent with the individual needs is their next statement. Look for a tool that allows tracking and documentation not only of the total score but of the sub-score. When you look at the sub-scores in a risk tool, that helps drive individualization of the care plan. Keep your goals individual to the patient. Not every wound will heal, and that's important to remember when we're setting out goals in wound care and wound care documentation. Document your goals clearly. Perhaps a patient's clinical status, their history of noncompliance, or the location of the wound will create an environment where healing is not an appropriate goal, but maybe maintenance and non-infection is more appropriate. Make sure that's clearly documented, and the discussion of those goals is documented not only with the resident or the patient, as well as their family and the rest of the care team members. Standards of practice should be followed. Standards of practice tells us to include the whole picture of the patient. So you're supposed to look at the whole patient, not the hole in the patient. I know that's an old phrase, but it stands true even today. Some of the most frequent gaps in documentation, it can include things that get mixed like nutrition, repositioning, support services, and hemodynamic instability. All of these need to be addressed in your plan of care and your documentation. When documenting about nutrition, make sure that the role of the dietitian is clearly spelled out with regard to wound care itself. Sure, the dietitian sees every resident that comes into your building, but are they involved in the wound care team? Make sure that they're targeting their nutritional goals towards wound healing and not just generally. Develop a reliable report system for your CNAs. They see the most care in our patients. They see what's being consumed and what's not being consumed. Make sure that we give them a clear channel of communication and we listen to what they're sharing with us. Use your risk assessment tool to, again, monitor your sub-scores when it comes to evaluating nutrition. Repositioning and support services are equally important. Please remember that turning every 2 hours is a guideline, not a standard. You have to consider the patient's individual history, their specific wound history, and their clinical status when determining a turning schedule. One patient may be able to tolerate that 2-hour time limit, where another may only need 30 minutes before they have shut down perfusion. Let's not forget about the seated individual as well. Just because they're up in the chair doesn't mean they're not at risk for pressure ulcer development. Make sure that your support surfaces are individualized to the patient and the situation that they're in. Remember to use support surfaces when the patient is at risk and not just after the wound has occurred, and document use of those support surfaces. Assess and apply your support surfaces on a regular basis, and make sure that your staff have been adequately in-serviced on assessing the validity of those support surfaces. And hemodynamics, you know, any pharmacological or mechanical support that's required to provide adequate cardiac output or normal blood pressure constitutes hemodynamic instability. This can be most of our patient population in long-term care. Don't forget that the skin is an organ too. And when global or regional perfusion shuts down, tissue death happens, organ function fails, and organ failure can be happening in the skin before we even know it. Use your labs such as albumin and pre-albumin, especially in chronic wounds or slow-to-heal wounds, to identify needs for the patient and early organ shutdown. Monitor and evaluate. This is key. Care plans need to be active, not just a form in a book. Treatment protocols are great, but if you don't give them oversight, if you don't use critical thinking, they're another form in the book. They need to be involved in the patient care. Change your plan of care when a change is noted. If a wound has not shown progress or has shown decline in 14 days, then it's time to change up that care plan. Consider the use of an objective tool like the push tool or the Bates-Jensen tool to help you monitor and track healing. An example of this happened in a facility in downstate Illinois that I work with. They had a resident who had a history of noncompliance. He had multiple wounds that were both present on admission and some that had been acquired in the facility due to his lack of compliance. They documented well. They showed through their documentation that many of the wounds were unavoidable due to the patient's noncompliance. They included the family in their discussions and documentation. Yet when the state came in for their annual survey, they isolated this one resident for a tag because of his multiple facility-acquired wounds. When they dove into the chart and looked at the charting, they found that the wound size had not changed, and therefore they determined that the wounds were not getting better and clinical oversight was neglected. The facility, however, had incorporated the push tool and were able to track and trend it effectively within their charting by using the push tool to point out that the score was improving, other parameters in the wound beds were improving, and the fact that the patient overall was stable. They were able to argue against the F tag and eliminate it from their survey results. Using a standardized tool can be an effective way, both in risk management and in wound progression, to document.
Anne, thank you for that excellent summary of avoidable versus unavoidable pressure ulcers, because we all understand that if we avoid wounds in the first place, we minimize legal risks that may occur later. What I'd like to do is point out to you that there's an opportunity to ask questions. You can ask questions in the question portion of your dashboard, and you can type the questions in and we can see you. Unfortunately, given the large number of people on our webinar today, you're all muted, so we can't hear your voice as you ask questions, but we did want to give you the opportunity to type them in as we go along. And what we might choose to do is if some questions arise, we'll ask Anne or Tim as they're speaking, but we also have a portion of the webinar devoted to questions at the end of the session today. We're planning to get everybody out within 60 minutes time frame, and that's allowing for a generous portion for questions today. So at this juncture, what I'd like to do is turn this portion of the webinar over to our panelist, Tim McVey, who is an attorney and a partner with the law firm of McVey and Parsky. And Tim is very experienced in representing the legal aspect of wound care, and we've asked him to share some thoughts with you today about avoiding common pitfalls. So what I'd like to do is to turn this over to Tim now. Thank you.
Good afternoon, everyone. I know many of you are not from Illinois, and I also understand that many people that are on this webinar are affiliated with hospitals and not long-term care facilities. I believe the issues are the same for both long-term care as well as hospitals. The first slide that you have in front of you kind of gives you an idea of what the Illinois Long-Term Care or Nursing Home Care Act statute involves. I know that other states have other statutes. Here in Illinois, one of the key factors of the Nursing Home Care Act is that it makes a facility liable for a resident's attorney's fees and costs for bringing a cause of action. Basically, the first slide gives everyone an idea of what's at stake in a case brought under the Nursing Home Care Act or a case brought against a long-term care facility. We have survival damages, which include pain and suffering, medical bills, disfigurement, loss of a normal life, disability, emotional distress. All of those damages are recoverable under the Nursing Home Care Act. Those damages set the guidelines for what type of attorney's fees can also be recoverable. The Nursing Home Care Act here in Illinois also provides that the facility is responsible for the intentional act of employees. Therefore, the beyond the scope argument that's often used is inapplicable here in Illinois. Our statute does not provide for the award of punitive damages. That is one big difference between the Nursing Home Care Act here in Illinois and other acts around the country. Also, because of that, many people outside the state of Illinois, where many of the real large verdicts have taken place, have to deal with all sorts of evidence that may not be relevant here in Illinois. To give you an idea, here in Illinois, the big factor that pushes more and more Nursing Home Care Act cases is the recoverability of attorney's fees. In one case that I tried where the verdict was $136,000, the attorney was awarded over $400,000 in attorney's fees by the court. The next slide talks about admission documentation. This is where it all starts. Plaintiffs' attorneys around the country that deal with long-term care litigation will tell you this. It's not going to be about the medicine. It's going to be about the documentation. As Ann stated, because of the regulations, the regulations state that a resident should not develop a pressure ulcer unless it's clinically unavoidable. Thus, once a resident develops a pressure ulcer in a facility, the burden of proof shifts to the defense side of the table to show that the development of that pressure ulcer was unavoidable. In order to do that, the facility has to have the appropriate documentation in its chart, since in many instances the litigation that develops occurs long after many of the employees are gone. They have no recollection of the resident or the issues surrounding the development of the pressure ulcer, and without the documentation in the chart, it becomes very difficult for a defendant to be able to show that an ulcer was unavoidable. This all starts with the admission documentation. As we all know, residents come to long-term care facilities typically with a transfer form. A transfer form lists medications and certain diagnoses, and that's about it. I know that in my experience here in Illinois, hospitals are getting more and more savvy in terms of sending a whole slew of records with a resident to a nursing home. Once the nursing home has these records in their possession, then plaintiffs' attorneys can point to them and argue that they should have known what took place in the hospital and should have known about various conditions, even though they're not referenced on the transfer form. When a resident comes into a nursing home, they can come in at any time of day, and as a result, the level of experience of the person who's performing the original nursing assessment can vary greatly. You have an LPN or an RN, you could have somebody who is just starting and they're supposed to do a head-to-toe assessment of a resident when the resident walks through the door. It's this admission documentation, and this applies to hospitals as well, that kind of sets the tone in terms of whether or not the resident came in with wounds that were already there, sets the tone for what the comorbidities of the residents are, what the resident's nutrition is like, what the resident's hydration is like. These things should all be documented and documented consistently when the resident walks through the door. If there is a poor admission assessment performed, you have an uphill fight in terms of being able to justify the documentation that follows from the admission assessment. The next slide. I attended a Defense Research Institute, a nursing home conference in San Francisco a few years back. And at that conference, James Wilkes of Wilkes and McHugh spoke. Mr. Wilkes is a very, very successful plaintiff's attorney who has made a substantial living suing long-term care facilities. Mr. Wilkes had absolutely no qualms about getting up in front of 500 defense attorneys and making this statement. He said, by the time we get done with the jury, they're not going to care one iota about the resident's medical condition. Plaintiffs' attorneys around the country who specialize in long-term care litigation want to make it about the documentation. They want to make it about what's not in the documentation. They want to make it about alterations in the documentation. They want to make it about inconsistencies in the documentation. They want to make the nursing home or the facility look as though they do not know what they're doing, that one person assessment differs from another person's assessment on a daily basis. They want to make sure it's not about medicine. The next slide gives you an idea that even the government makes mistakes. As you can see in this particular slide, the government assessed a $41 million fine against the facility, which obviously wasn't paid. But the point, the emphasis is everybody makes mistakes. Everybody's going to make mistakes in charting and in a chart. The next slide gives you an idea of plaintiff's counsel's pointing to alterations in the chart, where you have changes from the staging of a wound or the numbering of a wound. As you can see in both documents, you have handwriting over what was originally written in wound assessment documentation. It's just such alterations or clarifications that plaintiff's attorneys hang their hat on in terms of trying to show that somehow the facility is altering its documentation, and that as a result the documents should not be believed in toto. The next slide gives you a list of, I should say, next slide gives you the an indication of how poor documentation can really pose a problem. If you take a look at the bottom of that, you'll note that the same person documented all 31 days in the month between 4 and 6 p.m. for the turning schedule. In other words, the person worked 31 straight days at the facility. When plaintiffs' attorneys start asking for documents in long-term care cases, what they do is they ask for staffing records, then they ask for payroll records to be able to compare who's getting paid on what day to determine whether or not the staffing schedules or the initials that are found in the chart don't correspond to people who are actually at the facility. Next slide, please. To give you an idea, in one case that I had, I represented a facility and there was another nursing home facility that the resident had been at before our facility. And looking over that facility's records, it became apparent that one nurse charted separately on 6 pieces of paper care that was given to a resident, vital signs that were given to a resident. And if you took those pieces of paper and compared them to the nursing chart, you found that all of the entries in those records were on dates where there were no nursing notes in the regular chart. And the reason for that had to do with Medicare reimbursement. Needless to say, that case settled for a very large sum very quickly once it became apparent that somebody was charting to fill in the blanks, especially when the plaintiff's attorney asked for the payroll records from the facility, which indicated that that particular nurse wasn't even there on half of the days. What plaintiff's attorneys look for are internal inconsistencies. They start with the admitting assessment to determine exactly what was noted upon admission. Oftentimes, an admitting nurse will not pick up on a purplish mark on the sacrum, will not pick up on various wound conditions on the body. And the next thing you know, if the admission was on a Friday night, the wound nurse does not come on duty until Monday, and the first time you have a documented wound in the chart is on Monday. And obviously the argument is going to be that the wound developed at the facility as opposed to the wound being in existence upon admission of the resident. You have your histories and physicals, care plans, RAPs, MDSs, progress notes. All of these are looked upon by plaintiffs' counsels as a way of trying to undercut the care that was given at the long-term care facility. They try to find all the inconsistencies that they can. They try to find what isn't documented, a lack of charting. They typically try to point out that the medical chart, even though we all know that turning and repositioning in most situations is not something that is documented in the chart, they try to show that a lack of documentation once again undercuts any argument that the development of a pressure ulcer at the facility was unavoidable. In one case, we had the doctor, the resident's doctor was being deposed, and as a result of all of the omissions in the treatment records, the inconsistencies in other parts of the medical chart, by the end of the deposition, the doctor had to admit that he couldn't rely on anything that was contained in the chart. He had no idea what care was given, and this is a doctor that was trying to assist the facility because it was a doctor's opinion that the wounds that developed in the facility were unavoidable given the resident's overall physical and medical condition. Okay, this is a documented case study. The wound that you just saw, the photograph of that wound was taken at a hospital. Let me describe the case for you. This is a terminal cancer patient with tumors that were crushing her spine. As a result, she refused to be turned and repositioned. She also refused pain medication because she wanted to have a clear head and be able to talk with her daughters. The nurse who was charting on this particular resident was a very good nurse who happened to go on vacation for a month. The staff followed directions that the resident gave them in terms of not repositioning her and not providing her with pain medication. The doctor basically took the position that the resident was a terminal cancer resident, that there was nothing that the facility could do, that they were supposed to make her comfortable. The family had been counseled on their mother's wishes, and the subject of hospice came up. Unfortunately, none of the above was documented. Wounds gradually got worse as depicted in the photograph. One day the resident took a turn for the worse and was sent to a hospital. When the nurse arrived at the hospital, I should say when a resident arrived at the hospital, the emergency room staff contacted the state police. The state police came out and took photographs. The state police contacted the state's attorney. The state's attorney convened a grand jury, and as a result of a failure to document what the resident wanted, what the family understood was happening to the resident, and the grand jury indicted the doctor and indicted one of the individuals from the nursing home. The wound nurse that dealt with this woman was a sweetheart, and unfortunately she was gone for a month. Nobody documented on what the resident wanted, what the daughters wanted, or what the doctor had to say. And as a result, there was a huge settlement of the civil case and a criminal indictment.
Tim, thank you for that excellent case. I'd like to interrupt you because we just had a question come up that I think ties in very well with this case. The question comes to us from the audience, and they'd like to know, how does staff turnover impact a facility's ability to mount an effective defense? Do you have any comments for us in that question?
It makes it very difficult to mount a defense. Typically, long-term care plaintiffs' attorneys want the payroll records from the facility and the staffing records because they want to find somebody. They want to find the lowest common denominator in order to put on their case. They want to find a disgruntled employee. They want to find somebody who basically is going to comment that they were overworked, they couldn't turn the residents, they had no time to do this, that, or the other thing. Turnover at facilities makes it very, very difficult to defend cases, especially when that turnover is as a result of disgruntled employees being terminated, employees that aren't doing their job being terminated. Makes it very, very difficult. Next, we have another case study. This is for those of you in a hospital setting. A woman has a knee replacement. The knee replacement becomes infected. The resident had prior kidney problems. She undergoes a surgery to remove the prosthesis, and she is put on IV antibiotics, one of which is gentamicin. The gentamicin, it can have a negative impact on kidney function. The infectious disease doctors at the hospital had a plan that they were going to discharge the resident on Rocephin, not gentamicin. The discharge nurse called the infectious disease doctors for discharge orders. I shouldn't say discharge orders. She called to figure out what medications were going to be continued upon discharge. The infectious disease doctor that was following the resident had gone on vacation, so his partner was contacted. The nurse was told to look for the last plan in the chart of the attending infectious disease doctor. She found the wrong one. The plan she read to the partner had the resident continue on vancomycin and gentamicin. As a result, she put that on the transfer sheet. The resident was transferred to a long-term care facility. The transfer documentation listed vancomycin and gentamicin. The nursing staff at the facility contacted the doctor. The doctor continued the gentamicin and vancomycin. The doctor ordered a blood workup to determine kidney function. The blood workup came back the next day, late in the day, indicated that the kidney function was slightly compromised. The doctor continued the gentamicin and ordered a stat lab. Gentamicin was continued, and by the time the stat lab came back, the resident's kidney function had ceased. She was going to be on dialysis for the rest of her life. The plaintiff sued the hospital, sued the infectious disease doctors, sued the long-term care facility, and sued the attending physician at the long-term care facility. The jury came back. This was a 2.5-week trial. There were 10 or 15 experts. And I should pass this along to you. During the plaintiff's case in chief, the plaintiff put on a nephrologist expert to talk about damages. And in the process of asking the question to the expert, the number 3.2 million in terms of past damages and future damages was mentioned. The judge ruled that the expert was not qualified to render that opinion, but the jury heard that number. Jury deliberated, and as a result of the deliberations, they cut the doctor loose, they cut the long-term care facility loose, and they cut the infectious disease doctors loose, and they entered a judgment against the hospital for $3.2 million for merely issuing a transfer form that was inaccurate. That judgment was then turned into a $6.7 million verdict because the appellate court ruled that the judge made a mistake when she did not allow the nephrologist to testify as to damages. So as you can see, documentation issues can have a major impact on both hospitals and long-term care facilities.
Tim, thank you for that excellent summary of the problems and pitfalls involving documentation from a legal aspect of wound care. What we'd like to do now is take a short break and ask you for another poll. This poll, which should be appearing on your screen shortly, will ask you, what is the single biggest obstacle your facility faces in wound documentation? And we'll give everyone the next 30 seconds to submit their answers, and then we will share these answers accordingly. So everyone should be seeing the results of our poll right now. Thank you very much for everyone who voted. Next, I'd like to resume the presentation, returning back to our speaker, Tim McVey, from the law firm of McVey and Parsky. And Tim is going to talk about a subset of wound documentation involving wound photography. Tim.
I know that this is a topic that there are pros and cons about. In many companies, long-term care companies, many insurance carriers of long-term care companies have taken the position that they would prefer that there be no photographs because they fear that if photographs are taken, they can be used at trial against whether it be the hospital or the long-term care facility. I have found, especially over the last 5 years, that more and more hospitals are photographing wounds upon admission to the hospital. They want to document the condition of the wound upon admission. They do not continually photograph the wound, but they want to at least establish what the wound looked like when the resident was brought to the hospital. It's my position that, and I'm going to give a case study in a second as to why I hold this position, that it's imperative that if you have a serious wound or what appears to be what could become a serious wound, it's advantageous for the nursing home to photograph it upon admission of the resident. It documents what the long-term care facility was faced with upon admission. It can, if the wound is open, explain how sepsis develops, how the wound gets infected, and so forth and so on. I don't believe it's all that necessary to continue photographing the wound during the course of a hospitalization or a long-term care admission. But I believe it's crucial, at least from a defense standpoint, litigation standpoint, that if you have a wound that was there upon admission, that it be photographed. Now, I know that some people fear that there are some HIPAA issues that go along with such documentation. I don't believe those are insurmountable. I believe that just like a medical chart can be sequestered so that it is not given to people who don't have the authority to look at it, I believe the same thing can be done with photographs. I believe that the photographs, however, have to have the necessary information such as a patient ID, a wound location, and a date and time on them so that they can be placed in the file or in the chart, whether it be an electronic chart or it to be a separate wound chart that's kept separate and apart from the resident's medical chart so that we know what date we're talking about, what resident we're talking about, what wound location we're talking about. I think it is, well, let me just put it this way. I'm going to give you a case study, and I think this will speak louder than anything I could talk about. I had a case where there was a man was hospitalized. He had a change in condition. He was hospitalized for 10 days. While in the hospital, he developed a sacral wound. The hospital, and this is oftentimes the case, the hospital stages it like a 1 or 2. When he comes into the nursing home stages it as a 3 or 4. The hospital records were very sparse about the sacral wound, only mentioning it as a minor skin condition. When the resident comes into the long-term care facility, that wound's photographed. It's obviously purple, it's red, and it's open. It is not a stage 2. In fact, the photograph showed a substantial amount of purplish coloring surrounding the wound. As a result of that photograph, I was able to cross-examine the plaintiff's expert, who had to admit that the wound had all of the signs and symptoms of a deep tissue injury, and that that wound was going to get bigger and bigger before it was going to heal. Well, what ended up happening was the resident was in our facility. That wound opened up. It became a 20 by 20 centimeter sacral ulcer down to the anus. As a result of that wound, the resident was then sent to the hospital. When the resident got to the hospital, a decision was made to put the resident on hospice. He was then given Roxanol and expired. We were the only defendant in the case. The photographs were horrible, and the jury found in favor of the long-term care facility. And it's my firm belief that the reason why they found in our favor was that photograph and what I could use that photograph for in terms of cross-examining the plaintiff's expert witnesses. I even was able to cross-examine the doctor, basically saying this is an open wound, this wound is colonized, and it's only a matter of time before this wound's going to become infected. And he had to agree with me. That agreement, along with the wound nurse's admission that it was a deep tissue injury, I believe led to our defense verdict.
Tim, thank you for those excellent thoughts on the value of wound photography in mounting your best defense. What I'd like to do now is ask one last final poll of our audience. I'd like to share with you a question that you will see shortly about your own photography protocol. So I'd like everyone who's participating in the webinar to please vote what best describes your facility's wound photography protocol. If you could please submit your answer, and in 30 seconds I'll share with you the results of this poll. You now see the results of our poll. Thank you for the vast majority of you who voted. I want to thank you for participating in this poll, and we can see that the vast majority do not use wound photography. What I'd like to do now is wrap up the prepared content of our webinar today and summarize what we covered in avoiding costly legal pitfalls in wound care. Nurse Ann Scheurich discussed for us avoidable versus unavoidable pressure ulcers and the 8 critical steps in documenting them. And Attorney Tim McVey went through documentation standards for us, providing us a legal perspective and some case studies on how your documentation is really your best defense. And lastly, Tim shared with us his personal feelings about the use of wound photography and how he has been very successful in using this to his advantage in court.
Any questions?
What I'd like to do now is to thank our sponsors before we open this up to questions. And I'd like to thank our sponsor, McVey and Parsky, the law firm which Tim is a partner and founder, and thank Tim for his resources in providing us today with this material and sharing with us his vast experience in defending nursing homes and others who experience wound care litigation. Tim, thank you today for sharing with us. I also wanted to thank Ann Scheurich, who is the Director of Clinical Services from WoundRounds. WoundRounds is also a sponsor of this webinar today, and Wound Cares is a point-of-care wound management and documentation solution that empowers the clinical care team to deliver better wound care in less time. And there are some well-documented benefits behind the WoundRounds product that you're seeing now on the screen. What I'd also like to do is to, before we open this up to questions, I did want to show you guys that the WoundRounds team is preparing additional upcoming webinars in the area of wound care, and we've got 2 coming up before the holidays are upon us. So we have clinical reimbursement in wound care that kicks off on Wednesday, November 9th, and we have technology for improved wound management that kicks off on Thursday, December 8th. Everyone who's a participant in today's webinar will automatically get an invitation for these webinars. Additionally, you can request an invitation by going to www.woundrounds.com. At this time, what I'd like to do is to open the floor up for questions. I think that we had some questions that were coming in while we were doing some polls, so I'm going to take a look and see what questions have come in. And what I'd like to do is, I see, here's a great question that came in for Ann Scheurich. And Ann, I'm wondering if you have any recommendations on how facilities can best handle patient admissions, particularly after hours and particularly over the weekends, as oftentimes the wound care nurse is not on scheduled duty. Ann, might you have any thoughts you can share with the audience today?
Sure, Deb. As Mr. McVey pointed out, good documentation is good documentation, and nursing standards of care dictate that we document what we see and what we know at the time of admission. So just because your wound team, your wound nurse, or your wound expert isn't in the house doesn't mean that the admitting nurse cannot do a comprehensive assessment. The key is to chart what you see and what you know. Don't go outside your scope of knowledge by staging something that you're not sure of, but describe it as to the best of your ability and as accurately as you can. Again, Tim pointed out that admission documentation is crucial, and so at least saying that the wound exists, where it's located on the body, and what it looks like to the writer is a good place to start.
Ann, thank you for answering that question. I also noticed another question came in. This question I'll direct towards Tim. Tim, in your experience, what are the standard hospital practices for wound photography upon patient admission?
In the last few years, I'm seeing more and more hospitals photograph wounds upon admission. I think that when they have somebody come in from a long-term care facility, and there's a wound on that patient, They don't want to be dragged into litigation with the long-term care facility. They document them. I mean, I can't remember seeing a hospital chart in the last year or so that didn't contain photographs of wounds that were present upon a patient's admission to the hospital.
Tim, thank you for that summary. I also wanted to acknowledge that several people have asked questions about the push tool, and I have given those folks an opportunity to provide with us their email address, and we'll be more than happy to send documentation about both push and braid-in to those folks afterwards. I want to extend this offer to everyone who's on the webinar today. If you simply go into the questions portion of your dashboard, if you want to provide us with your email address, we will share with you after this webinar a copy of the braid-in and the push link, which enables you and your facility to learn more about these standardized tools in the area of wound care. So I see that there's another question comes in. If you can give me a moment to read this question, and then we'll see if we can push this out to one of our panelists. At this time, I'm not seeing any additional questions, so what I'll do is talk to you about the next steps. Besides giving you our thanks for joining us today, we'd like to make sure that you get some parting gifts. Your parting gift will be a copy of this recorded audio and a copy of the presentation slides that were used today. So everyone who is a registered attendee of this webinar will receive a copy of that after the fact. So I wanted to make sure that everybody knew about that. And if there's any other questions, I'd like to give you another 10 seconds to please submit them. Otherwise, I'm going to, again, thank my panelists, Ann Scheurich, Director of Clinical Services at WoundRounds, and also Tim McVey, Attorney and Partner at McVey and Parsky, for sponsoring this webinar today and also for sharing their incredible knowledge base with us. So at that, I'd like to thank everyone for participating, and I will hereby close this webinar now. Thanks again for your participation.